Hello everyone and welcome to the Bird International L&E Club. In this podcast series, we will hear from our international team of employment law experts on a variety of cutting-edge topics. Each episode will provide 5 key takeaways on a key L&E theme with a US focus in 10 minutes. I'm Patty Walsh, a US-based partner within the L&E group here at Bird and I co-head our San Francisco office. Welcome to our L&E Club podcast series, 5 key takeaways in 10 minutes. Today I have one of my favourite colleagues, Rob Briggs from our London team. Rob and I work together almost every day, and Rob is here to answer the big question. The UK post-Brexit, what's the labour and employment law horizon? Over to you, Rob.
Thanks, Patty. So before going into my 5 takeaways, it's worth taking a couple of minutes to talk about where we are. The UK left the European Union in January 2020, and there was then a transition period until December 2020. In a sense, one of the striking things about employment law since Brexit is the fact that nothing has really changed. A lot of the arguments of Brexit were around taking back control from the EU, from where lots of our UK employment law derives. However, there was a degree of tension in that many of the politicians promoting Brexit wanted to make the UK labour market more flexible and less regulated, the so-called Singapore-on-Thames vision. But this view isn't necessarily shared by some of those who supported Brexit, and it wasn't communicated in some of the messaging around Brexit. In addition, in the immediate period following Brexit, the government were perhaps understandably focused on dealing with the COVID pandemic. More recently, however, there's been a growing perception amongst Brexiteers that progress has been too slow. So in December 2020, the government tabled the retained EU law revocation and reform bill. And this is my first key takeaway. The headline effect of the bill was to sunset or revoke all retained EU legislation by the end of this year, with some exceptions such as financial services. There was scope for ministers to decide to either retain, replace or revoke legislation, as well as delaying the point when the legislation would be turned off beyond the end of this year. The removal of any EU legislation would also call into question the status of any rights from case law that derives from that legislation. These proposals created some significant uncertainty. It wasn't clear what laws would be revoked and what would be kept. It wasn't even clear how many laws would be subject to this sunsetting provision. And there were question marks around whether there was enough manpower within the civil service to consider and make all the associated changes. However, in response to some of these concerns, recently the bill was amended so that the list of legislation that would be automatically revoked has been substantially slimmed down. There are no employment laws in the list, apart from some regulations that are very minor or are genuinely obsolete following Brexit. For example, around the concept of posted workers and so-called European cooperative societies. The amended bill is now in force and has become an act. Despite the change to the sunset clause, the Act still gives government ministers significant new powers to reform EU-derived laws. The scope for such reform is technically somewhat limited, as the trade deal that the UK and EU agreed in December 2020 commits the UK to maintaining certain standards. Specifically, the trade deal includes a non-regression clause, stating that neither the UK nor the EU can weaken its levels of social and labour protections in a manner that would affect trade or investment between the parties. For my second and third key takeaways, I'm going to focus on those areas of EU employment law where the government is considering making some material changes, specifically around working time and TUPE. The UK's working time regulations implement the EU's working time directive and govern areas ranging from working hours to holiday pay. In relation to holiday, in the UK, statutory holiday currently comprises 2 elements. Firstly, 4 weeks holiday derived from EU law, and then an additional 1.6 weeks, which comes solely from the UK law. This totals 5.6 weeks statutory holiday a year, which is 28 days for a full-time worker, and all of this must be paid. The complication comes from the fact that case law that derives from principles in the EU directive has found that the first 4 weeks holiday must be paid based on all of the components that comprise a worker's usual pay, so for example, overtime pay and commission. There are also different rules between the 2 elements of holiday in relation to carryover into future holiday years. So the government is therefore proposing to merge the 2 elements. However, the government hasn't stated whether it proposes that this single statutory holiday entitlement would be paid like the current 4 weeks, which would be more generous for workers, or like the current 1.6 weeks, which would benefit businesses. The government also acknowledges that it would be challenging to clearly define the rate of pay into legislation. The government is also proposing to make changes to so-called rolled-up holiday pay. So this involves paying additional pay covering holiday entitlement to workers for the time when they are performing work, rather than when they're on holiday. It's relatively common for some categories of workers, such as workers on 0-hours contracts in the gig economy. However, currently it's technically unlawful due to concerns around whether such workers are currently incentivised to actually take holiday. The government is considering making it lawful for all workers. Finally, the government is consulting on requirements around keeping records of working time. There was a Spanish case in the European Court of Justice in 2019, which decided that employers must have a system measuring working time to ensure that laws around rest breaks and maximum weekly working time are complied with. The UK government is proposing to confirm that this case doesn't apply to the UK. Of course, many UK employers monitor working time for all sorts of other reasons, and are likely to continue to do so, including ensuring workers are paid for the right number of hours and are paid the national minimum wage. The area of EU employment law where the government is considering changes is TUPE, which is my third key takeaway. TUPE stands for the Transfer of Undertakings Protection of Employment Regulations, and it governs what happens to employees in cases such as outsourcings and transfers of businesses between two legal entities. Under TUPE, employers are required to inform and consult with appropriate representatives of affected employees, which often involves setting up time-consuming election processes, even though employees may be happy to be consulted directly. The government is proposing to allow businesses to consult directly with employees where the business has less than 50 employees or where there are fewer than 10 employees transferring, assuming that there aren't any existing employee representatives already in place. For my fourth key takeaway, I just wanted to highlight that there are a number of proposed changes to UK employment law that are entirely separate from the EU and Brexit. These include changes to the flexible working regime, including allowing employees to make a request from day one of their employment rather than just after a certain period of continuous service, extended redundancy protection for women and new parents, and a new duty to prevent sexual harassment and the reintroduction of employer liability for harassment of employees by third parties. Perhaps most interestingly, there's a proposal to limit the duration of post-termination non-compete restrictions to 3 months. These are often much longer than 3 months for senior employees, and this change would be really drastic, potentially even applying to non-competes that were agreed with existing employees before the legislation came into force. Note, we don't yet know if or when these proposals will become law. Indeed, for my fifth and final takeaway, I wanted to flag a change that could well impact everything that I've said up to this point. We're due to have a general election in 2024 or possibly 2025. If opinion polls are to be believed, there's a good chance that our current Conservative government could be replaced by a Labour government led by Keir Starmer. In the last couple of years, there have been statements from the Labour Party around changes like making unfair dismissal protection a day one right, rather than employees needing to have at least 2 years' service with their employer, as well as changes to the controversial fire and rehire process for imposing changes to terms and conditions. It remains to be seen whether these proposals make it into Labour's manifesto, or indeed whether they win the general election, but it seems clear that a Labour government would bring a much more worker-friendly employment law regime than the more business-oriented approach of the current Conservative government. So overall, after a period of relatively little change in employment law in the UK, there are a large number of developments on the horizon, from the more modest proposals around TUPE to more significant shifts if there's a change of government. So whether or not these will happen and when is essentially unknown, so employers need to keep things under review and be prepared to act quite quickly to adapt to any changes. So yes, watch this space. Back to you, Patty.
Thank you so much indeed, Rob. We will definitely continue to talk to you over coming months and see whether or not Singapore on Thames really does become a reality. Thanks again. Thank you for listening to today's podcast. We hope you join us again and look out for more content coming soon.